Good evening, everybody. Hope everyone is doing well. As you all probably know, there is a hurricane, I think it's Hurricane Helene, bearing down on Florida. We're supposed to get some rain, quite a bit of rain, I think 8 to 10 inches of rain tomorrow, 35 miles an hour wind here in Atlanta. So I don't expect we're going to have any power outages tonight, but if for some reason I go off the air, that's because we had a wind gust or something that knocked us off the air. But it's raining here in Atlanta, but not too bad yet. But obviously, if you are in the path of the hurricane, take cover, be real careful because these are dangerous, not just the hurricanes, but the tornadoes that go along with them many times. So we are all thinking of you if you're in the path of the hurricane. Basically, we're going to have about 4 or 5 days of just flat out rain, which is going to be, again, there's going to be some flooding. If you're in a low lying area and you get a lot of rain, you want to be real, real careful because you hear these horror stories of people getting stuck in their car, being washed away. So be very, very careful out there. Okay, let's go ahead and start with the questions that I've already gotten a few, which I really appreciate. Carolina Bread, and I suspect that if you're in Carolina, you're going to get some of this rain as well. Asked an interesting question. If you meet a mental health listing, but applied for both mental health and physical disability, would SSA still schedule physical CE consultative evaluations or just determine disability on the mental health listing without further inquiry into your physical ailments? Simple answer to the question is that the adjudicator is going to make a decision about whether to send you out for a mental consultative, a physical consultative, or both. They're going to look at the application, they're going to look at the medical records they've got and make that determination. And this, and a larger point I want to make, and this is something that, I had this conversation with some clients, potential clients over the course of the last week. There are no guarantees in Social Security. There's no slam dunks. And I've had people call me and say, I know I meet a listing. Clearly I meet a listing. I want to get approved early. And absolutely, I'd like to get people approved early if we can. But you could meet a listing by the letter and you could still end up being denied. Adjudicators or essentially claims adjusters, they are doing the best they can with what they've got. And if they're really, really busy, I've seen situations where cases that clearly should have been approved are not approved. So there is no such thing as a slam dunk. Anybody who tells you they can guarantee they get you approved in 3 or 4 months, and it's just not true. And, I think that you go into Social Security with the idea that, in a best case scenario, this could be 8, 9, 10 months, but assume it's going to be 24 months, 30 months, 2.5 years. Because if you assume you're going to have your benefits in 3 months or 6 months, you're really, really looking at a big disappointment because Social Security just doesn't do things that efficiently. So I just would tell you, don't assume that no matter how good your case is, it's going to get approved, lawyer or not, because I can stand on my head, provide all the documentation I want. The adjudicators, they don't have to call you back. They don't really answer to anybody, and they may just ignore everything I say, and they may ignore the medical record. And just like some judges are not going to approve cases that should be approved, you have the same true with some adjudicators. Many of them want to do a good job, want to do well, but they're not always trained properly because Social Security has a real problem with turnover. And they may not understand fully the grid rules. They may not understand the listings or equaling a listing if you don't meet one. So don't assume that no matter how good your case is, it's going to be approved automatically or quickly. Okay. G.I. Jose, who's a regular. 6 weeks, the ALJ made a decision waiting on the rep to finish the non-medical 15 to 30 days. If it goes for several days, does that indicate approval? Does SSA call you to make sure the info is correct? Well, if you had a hearing 6 weeks ago, you're kind of in that time frame to get a decision. The non-medical is to confirm you're not still working. There's no activity. So it's certainly possible that if they're going to do the non-medical, that does sound to me like you were approved. Now, they could have approved you and changed the onset date, called a partially favorable approval. And I've seen that happen where you end up with no past due benefits because they changed the onset date to last month. But generally speaking, SSA will reach out. They don't like to call you because there's so many scams. They'll usually reach out, ask you to fill in a form, or they'll check with the IRS to see are there any earnings. But if it's been 6 weeks and you see that it's a non-medical evaluation for work, that's usually a pretty good sign, I'm thinking. Justin says, I had my CE exam recently, and I guess the doctor stated that you cannot work substantial gainful activity, which is the standard. You have poor function, severe anxiety, depression, neurocognitive disorder. They denied you 2 days after reviewing the report. SSA is biased and broken. My only response to that would be that that the consultative evaluation doctors don't always speak Social Security's language. I've read many, many consultative reports that contain nothing in the form of functional limitations. They don't talk about it at all, especially in the physical side. And in the mental side, they may be ambiguous. So, Social Security, I would agree, has some real problems in terms of processing claims in a timely manner. Why this happened, I don't know. One option, one possibility is that the consultative evaluation report came in late. The adjudicator had already made a decision, or there's other evidence that the adjudicator felt was more compelling than the one-time consultative, any number of reasons. But it certainly is odd that if a consultative says that you cannot do substantial gainful activity and poor function in terms of a job, that you would get denied that quickly. And realize that the diagnosis that the consultative doctor gave you, anxiety, poor function, depression, unspecified neurocognitive disorder, that does not mean that you are disabled. It means that's a diagnosis. And so what you really need a consultative doctor to do is to translate these diagnoses into work limitations and realize that, if your case is purely mental health and you're in your 30s, there are certainly jobs out there, simple entry-level one-step jobs that one could do with, depression. And maybe there are jobs out there probably that one could do with limited interaction with others that would address the anxiety. So sometimes you need somebody to put it all together, and usually the consultative doctor is not the one to do it. But I would think that if you've got that supportive consultative, that would bode well for future appeals and hopefully an approval. Jenny Jo says, hello. Now, Jenny Jo left me a multi-part question, so let's kind of go through this. Had your CE exam less than 5 minutes, and the examiner said SSA hires him to see if people are faking. He asked, was there any particular test that he should do? Doctor's asking a claimant what test he should do. He barely checked your range of motion, didn't have symptoms, didn't want to see MRI reports, but did look at support letter. Let's see here. The nurse asked me my main reason for filing. I told her some things and gave her my disability support letter, said this would sum it up. Well, it's smart to have a disability support letter. Dr. Foster, and he's the one, in fact, I'll show you his YouTube channel real quick here. Dave Foster, and I've chatted with Dave a couple of times. He is a doctor. He's got a YouTube channel at Disability Exams where he basically goes through and he talks about, what a consultative doctor does. He, sports a real natty bow tie there, but he has some really interesting videos about what a consultative doctor does. So if you're interested in learning more about consultative exams, check out Dr. Foster's YouTube channel, which again is at Disability Exams, youtube.com/@disability exams. So let me go back to Jenny's question. And Dr. Foster said that anytime you have a 5-minute or less CE exam to tell SSA, I don't feel you could have learned anything. Would you agree to tell my adjudicator? I would say, let's see here, we got more. All in all, the CE doctor was actually polite and kind. I thought the whole exam was strange and short. Sorry for the lengthy question. Did say to make sure SSI has a disability support letter because it says a lot if that means anything. I mean, I personally would like to see this doctor's report before asking Social Security not to give it much weight. It's possible that that report is in your favor. So if you could get a copy of the report, I would do so, see what it says. And if it looks like there's some favorable things in there, you may not want to object to it. If there's unfavorable things, then you might object to it. You could always hedge your bets and wait until if you got to a hearing and that report had negative things in there that you could, raise it to the judge and basically say, this is what happened at this exam. And I would probably do that ahead of time with a statement. And then, ask your lawyer could ask the judge to give that exam little to no weight. So as far as whether you should notify your adjudicator, you know, I think at best it would mean the adjudicator would not give that exam any weight, which may not be in your favor. Or B, it could trigger the adjudicator to ask for another exam, which again may be worse. So I think I would want to find out what it says. That's my thought before saying anything further. All right, I've got this link down below as well. If you'd like a free case evaluation, you can go to the bit.ly link, contact Jonathan 3, and I'm happy to take a look at what you got. RD. Typically, when SSA contacts you and they advise they'll be obtaining your records from the VA, how long does it take to get them and review them for a decision or assign you to a in-person doctor visit? I think with the VA, if I'm not mistaken, the VA is part of the HIT system, Health Information Technology System, which means Social Security can get those records literally immediately. Somebody has to read them. And I will tell you, having gone through a lot of VA records, they tend to be very, very voluminous. It's not unusual to see a VA record, 1,500, 2,000 pages. So it can be really, really hard to go through. And a lot of it is, there's a lot of repetition in there. So, it may not be something that an adjudicator is going to get through very, very quickly. So I don't think there's any specific time frame. Having talked to adjudicators, what they tell me is that they request medical records once they get the file and they have a list of doctors. They request medical records and they may calendar it for 4 to 6 weeks to get it back. If they don't get records back from one or more providers, they send a second letter and again calendar that for 4 to 6 weeks. So you can already see we're at 3-4 months, and then once they get the records back, somebody's got to in their office has got to put them together, paginate them, put them in some sort of order, maybe eliminate duplicates, and then they take it to a doctor at Social Security who works under contract with Social Security to review files. And the doctor then looks at them, which could be another month, gets back to the adjudicator. The adjudicator is going to be looking at this along with a lot of other files. And then, at some point, they'll make a decision. So there's no specific time frame, but it's not fast. Scylla. Approved for SSDI, good for you, Scylla. Payments for suspended or denied paperwork from exhausted payments from STD. Paperwork was resubmitted. I'm confused because if STD is short-term disability, Social Security doesn't offset for short-term disability or long-term disability. In other words, the short-term disability carrier might offset, but Social Security won't. So I don't know why Social Security would have suspended your payments. It makes no sense to me. Now, if you're talking about state disability, there may be an offset there. But, this is one of the, let's just say whatever the reason was, they suspended your payments. This is a situation where, it's not in the normal course of business for Social Security. So that means that somebody, with seniority has got to look at it. That person is probably really, really busy. These are the type of problems, suspension of benefits because of a possible offset, and maybe who knows what, but it's got to be in somebody's file. It's got to be in somebody's office, and that person could be very, very busy. This is one of these situations where I would probably be fast on the trigger to contact my United States congressperson or senator, because this is one of these cases that, it's going to turn into this long drawn out, slog, because nobody at Social Security really knows what to do with it. And it just sits on somebody's desk, and you may have to get, a congressional inquiry to get things moving. So that's what I would do. But I've not heard of short-term disability offsetting Social Security. Maybe you're talking about, I don't know, because I know sometimes you see earnings records that look like you're working, but it's short-term or long-term disability, and that could be a problem. But that doesn't sound like what you got going on here, so I don't know. I do not know. Trish Wade, hello from East Tennessee. Hello, Trish. Rodney, hello. Rodney's a regular. How are you doing? John Rank, hello, John. Big One is always here. Hello, everyone. You made it in time. Last week, I think Big One was a little bit late. John Rank is giving I don't know, what is that called? It's a Hawaiian aloha or something. I don't know. I know people in Hawaii use that a lot. So if you're in Hawaii, maybe you could explain it to us. Fred Rodriguez says, once approved for SSD, I understand your child is eligible to get half of what you receive in benefits, but are they eligible to get the amount in back pay too if they're getting SSI? Okay, well, first of all, it's not half. It's a percentage of what you get. It's called an auxiliary, and a lot of times it's 25%. But again, there's something called a family max. So you have your amount, then you have your auxiliary would get a certain amount. But I think it's for a child is 25%. As far as the past due payment, yes, you will get whatever you get in terms of past due payments. Your auxiliary will get that as well. Will it offset their SSI? Yes, because SSI is a means-tested program, and disability is based on earnings, and so usually disability is higher than SSI. So to the extent that SSI is as much or more than SSDI is as much or more than SSI, then it will be offset, and that can create some problems. It doesn't mean your child is not disabled. It just means that they would be on SSDI, auxiliary benefits instead of SSI. And that it's usually not a huge problem, but just something to be aware of there. Let's see what we got here. Okay, Johnny says, hello, good evening. Hello, Johnny. Johnny's not been on for the last couple of weeks. You had to work. Well, I'm glad you made it. And by the way, next week, I'm pretty sure it's next week. Let me double check. I'm going to be I believe it's going to be on Tuesday next week. Let me just double check that. I don't want to tell you wrong. Yes, next week, it's going to be on the 1st of October, not the 2nd of October. So Tuesday the 1st. I'll put a message out, but just be aware next week it's going to be a Tuesday, not a Wednesday. All right, now we have SD. How can I get approved with having irritable bowel syndrome? Also have anemia with the fatigue and joint, maybe consider a secondary condition to IBS. I win a lot of cases on IBS because, again, the issue in a disability case is your capacity to be a reliable employee. And if you have uncontrolled need to use the restroom, and you are, let's say 5 to 7 to 10 times a day, and there are times when you may not make it, not to be gross about it, or that you may need to change your clothes, or you may need to be in the restroom for 15 or 20 minutes, that's going to take you off task from your job. So I think, the one area I will tell you that I routinely take cases of people younger in their 40s is irritable bowel, because it doesn't matter how old you are. If you have a diagnosed irritable bowel problem, you're going to have a hard time working. I just got an approval on a case for a very, very nice woman who's been struggling with this for years. She's 40, I think she was 46 or 47. And, she had a job, she had to leave a job. She tried like 3 or 4 different jobs that gave her, flexibility and freedom to use the restroom. Nothing worked. And she finally got to the point where she just couldn't do it anymore. Very painful, very unpleasant. So I think those cases are strong on the IBS part of it. The anemia and the weakness and the fatigue adds to that. Joint pain, yeah, I think so. I think you see this exactly the way I do, and that is that irritable bowel is a primary condition, but the anemia, the fatigue, the joint pain, those are things that are kind of secondary that remove even more potential jobs. So I think that sounds like a pretty good case, even if you're under 50. Deb Lindley says, stay safe. Yes, please stay safe. I just had actually a friend of mine who's an attorney in Jacksonville, Eric Berger, who I mentioned we're going to probably be doing some work together. He is a disability attorney and a long-term disability attorney. He sent me a text a few minutes ago saying, stay safe. We're preparing for the hurricane, so stay safe. I'm like, same to you, buddy, because I mean, it's definitely scary. So, okay. JC Sports was responding to RD that Social Security called him in Pennsylvania, said they're sending him to exam. They requested VA records and started claiming July. Things have been moving quickly. That's good. And some adjudicators work really hard to make things move quickly. So that's a really good thing. But yeah, that's kind of the way it works. Although, I don't normally see Social Security calling. They may use an automated messaging system and tell you to call them. But there's so many scams out there. I've gotten some of these calls on my cell phone. I get a phone call. This is the Social Security Administration. Your Social Security number is being suspended unless you call this number. And of course, they're going to want Apple gift cards taken to some, who knows what. Or they're going to want some sort of, untraceable money order or Bitcoin or something. So they're very reluctant to call you. So I think it's more likely they're going to write you, or they may send you a voice message asking you to call them. And of course, when you call them, double check the number to make sure that it's correct. And don't hesitate to ask for the person. If it's legitimate Social Security, they'll tell you their name, their employee number, that whole thing, so you can verify that. And if you're not sure, and you have to do it, you call back, get the number. There's a field office locator, by the way. Let me just show you that. I haven't talked about this before, but this is actually very, very useful. So let me show you how this works. Oops, hit the wrong button there. Let's go to share screen. Okay, so Social Security has something called a field office locator. It's just ssa.gov/locator. So if you want to find a field office where you can contact your adjudicator, if it's not in the letter you've already gotten, you can put a zip code in there. So let's just put in a New Orleans zip code. That's where I went to school, so I know the zip code. And it basically says, here's the number for Social Security's Poydras Street office. Now, in this case, they gave the 800 number, which is pretty useless, 800-772-1213. But they do have a fax number. You could certainly fax, and you can look online to see if that field office number is available. I actually have a spreadsheet with all the field office numbers. So it's not the most updated, but it does give me some. But you can usually find it if you look around, get the field office number for your particular place. So let's just try another one. I'll just do my local one here. And this is the North Shackleford Road. And here they give you the main number too. I don't know why they do this. They do have, most of them, they obviously have phone numbers, but they give you the 800 number, which you'll be on the hold for 30 minutes. So I would look for the real number as opposed to the 800 number. And if you get that real number, just write it down so you've got it. A lot of times it's on the notices that the adjudicator sends you. Okay, sorry the thing's jumping around. There's a setting on this webcam that causes it to follow you around, and there's really, I can disable it, but for some reason it keeps coming back on. I'm not sure why. Let me see if, here, let me turn tracking off. Let's see if that, looks like it turned off. Okay, good deal. But the way it works is if you do something like that, it'll start tracking you again. So technology. Michelle Smarts. I had my hearing and VE gave 3 possible jobs, the VE being the vocational expert. After the hypothetical questions asked by the judge, she said no jobs. Is this a good sign? The judge may ask, okay, let's back up and make sure I'm understanding. So when the VE gave 3, I just enabled it again here. I'm sorry to keep my hands down. I don't know why, if I can turn that off permanently. All right. The first thing the VE does is the judge will say, identify Ms. Smart's, this claimant's past relevant work over the last 5 years. So there would be jobs given with DOT titles, Dictionary of Occupational Titles. So if that's what you're talking about, that's just identifying your job. Now, the hypothetical question, assume a hypothetical person limited to light work, no climbing ladders, ropes, and scaffolds, no kneeling, crouching, crawling, or stooping. Any job needs to have a sit-stand option. The person could sit for an hour, but then would need a 15-minute break standing at the workstation and would not be off task. Any number of things. This individual needs to avoid extremes of cold, pulmonary irritants, loud noises, whatever it may be. So identifying the jobs is not a problem, what you did. And then after the hypothetical, if the judge asks, 3 hypothetical questions and all of them elicit the response, no jobs, that's a pretty good sign you've won. I will tell you from my experience that, I've talked to them on the phone and they'll ask me to review an unfavorable hearing decision, which I'm always happy to do. And they'll say to me, with no question, the judge did not ask a single hypothetical question to the vocational witness. I'll get the recording of it, and sure enough, there are 3 or 4 questions. It's just sometimes hard to kind of, it's been an hour, you've been in the hearing, you may not recognize what's really going on. But I would just say this, is that, it's always good when the vocational witness says no jobs. Now, I will tell you that almost every judge at the end of a hearing is going to ask a question, something like this: Mr. Vocational Witness, assume, no limitations, physical or mental, but assume that the person has minimal physical limitations, but because of mental limitations would be off task for 15% of the day or more, or this hypothetical person would likely miss 1 or more days of work per month. That is a layup, and every vocational witness will say there are no jobs this person can do. The judge asks that simply to make the record complete. But that doesn't mean that's what the judge is thinking. Many times the judge will ask a question that will generate a response of certain jobs, and the judge may choose that question or the next one where there are no jobs. So it really depends on how many questions the judge asks. If there's one, that talks about off task 15% or absent 3 or more days of work a month, that's just a throwaway. That doesn't mean anything. But the ones where the judge goes through a number of limitations and you get the response no jobs, that's a little more positive. And I've had situations where the judge will say, assume an individual can do, is limited to sedentary work with all these limitations, and the response is no jobs. Then the judge will say, assume light work, and all of a sudden jobs appear. So this is a case where you might want to ask your lawyer to download the audio and listen to it carefully, especially the last 10 minutes, to make sure you really heard what you think you heard. And I'm not being facetious. I'm just saying it's hard to keep a lot of this stuff fresh in your mind. But it's a good sign when you get no jobs, from the VE. It's also a good sign if the judge, is basically, seems very, very sympathetic to your cause, doesn't ask a lot of questions of you, or ask questions that suggest that the judge does believe you. I think that, most judges, but not all, most of them want to do a good job. And I think they recognize you've been waiting for a long time. And the better judges, in my view, will kind of give you a pretty strong hint as to what's going on, or they may tell you, I've heard enough to approve your case. Others don't, but, I think you've been waiting a long time. That's really probably the least they could do. So I'm sorry, I did have a tennis match this morning, didn't play this afternoon because it was raining. And I'll tell you what happened. I just get off my aside. First set, we lost. We should have won. We lost. Second set, it was, neck and neck. We're up 6-5. I'm serving for the set, to make it 7-5. And I've got a pretty good angle of what I'm trying to do with my serve. One guy was hitting it straight at him pretty hard. Other was doing a lot of spin. I'm lefty, so I can spin it into the body of a right-handed player. So, I got it, 15 love, 30 love, 40 love. And so it's starting to drizzle a little bit. And so I hit the next one and he hits it out. And I'm telling you, within 10 seconds of the point of us winning that set, the skies opened up and just it poured. So, we got to play a third set and makeup set at some point. But, that was it was a pretty busy morning because I had to get up really early. The air conditioning in my office went bad. We had to get a new air conditioning. I had to be there at 7:30 to let the guy in, or the air conditioning people in. And then I had my match from 10 to 12 at 12:30. And then I had my granddaughter over. I was chasing her around all day. She's just turned 1, and so she's very mobile, running around, crawling around. Had to keep her out of trouble. So that's why I'm yawning. Long day. Um, okay. John Rank. Had my hearing on May 14th. VE said no work available. ALJ agreed. Haven't heard anything from SSA. What's the deal? They're backed up. I just got a favorable decision in a case I tried in April. So I just think they're backed up. And, if you had your hearing in May, give it another month. Then if you don't hear anything in another month, I think it might be worth having your attorney contact the hearing office, or, reach out to the chief judge. Usually I would contact the judge first and ask what's going on, but you don't want to upset the judge, by being demanding. But I think if it's been like 5 months, I think it's okay to ask. But that's, like I said, I just had one from April approved today. Oh, I was playing tennis. Yes, I did play. As I just said, I had two sets. Both went. One went. We lost 5-7. The other won 7-5. So played a lot of tennis. This one guy was hitting the ball really hard, and so I was just sticking my racket out to get the ball back, and we broke him a couple of times. But he aced me a few times, and I had a couple of aces. So yeah, just try to keep active. You got to keep active. Well, I'm supposed to play. I'm on a second team. I'm supposed to play. This is a older team, and I played line 1, which is played their better players, and then I've got another team which is younger. I'm playing. People could be like in their 20s, and because I don't have anybody else to play. I'm the captain. I'm playing line 1 on that, which is I have a feeling it's not going to work out so well, but we'll see. I'll report back. We'll see. Leanne says, I applied for SSDI in April of 23, and because of not having enough insurance, I see a nurse practitioner, cannot afford an orthopedic. Is that good enough? Yes, for severe spinal stenosis. A nurse practitioner is an acceptable medical source. There is a ruling on that, Social Security ruling, which talks about who are acceptable medical sources, and a nurse practitioner is acceptable in a medical source. Now, it would be helpful if you had an MRI to go along with what that nurse practitioner is talking about. But yeah, diagnosis and treatment from a nurse practitioner is just fine. All right, Fred says, just approved. My AOD is in 20. Home back paid to my AOD. Is this correct? All right, so to clarify terms, AOD stands for alleged onset date. In an SSDI case, you can get paid 1 year prior to application. So if you applied in April of 2023, you can get paid from April of 2022, even if your onset date was April of 2020. You only get paid for 1 year prior to onset. Now, the 5 months can run, the 5-month waiting period can run before you become eligible for payments. So in our example, you apply in April of, April of 23, you're approved with an onset of April of 2020. The 5 months runs April or May, June, July, August, September, October, 2020. So by the time you get to April of 2022, when you're eligible for benefits, you get that full 12 months. They don't take the 5 months off then. The 5 months runs as of onset. But yeah, if you got your onset date more than a year, more than, let's say, 16 months prior to the date of application, you won't get paid going back that far. And that's why. Leanne, can I have an, okay, so Leanne was the one who asked about the nurse practitioner. Can I have a nurse practitioner refer me to MRI for lower lumbar system? Yes, absolutely. And realize, MRIs, you could go to an MRI clinic on your own. You don't have to necessarily have one referred, but if you get one referred by a nurse practitioner, by a physician's assistant, even a chiropractor, doesn't matter who referred it, you need a radiologist to interpret it, but, you can certainly have a, MRI, the radiologist interprets it, there's something going on, severe stenosis, herniated disc, whatever, then the nurse practitioner can, basically take the lead on treatment. And I realize there's some things they can do, some things they can't do. Certainly they're not going to do surgery, but they might be able to prescribe medicines and things like that, offer opinions as to your functioning. Okay, Deb. Um, okay, so Deb, I think, is referring to SD, and I think SD, if I'm not mistaken, was the irritable bowel case. Um, Deb says this is a lot like trying to win fibro and chronic fatigue. I disagree. I think that irritable bowel is a heck of a lot easier to win than fibromyalgia and chronic fatigue. Um, it is something that can be imaged. You can have a colonoscopy that can show damage to your colon, or the intestinal tract. So it's not like fibromyalgia where there's no objective testing. There is objective testing. There are degrees of impairment. You have a gastro as a specialist who can treat you and try different medications, different types of treatment. So I think it's a lot easier to win in my book than fibromyalgia and chronic fatigue. No disrespect to Deb, but I think this is a much different ballgame because irritable bowel cases, I mean, I love irritable. It sounds crazy to say it. I love those cases, but I'll take those cases all day long because I win them. I mean, they're just, judges recognize how significant it is. St. Louis Grand, good evening. Hello to you. SD, the irritable bowel, it greatly impacts my daily living, barely kept with cleaning my own personal needs, spread over a few days if I can do that. Yeah, this is an example of activities of daily living, are, judges look at them as kind of a surrogate for your capacity to do any kind of work. So, I think that, I think if you have a problem with activities of daily living, that's probably a pretty good sign you're going to have trouble trying to get through a work day. They go back 2 years. Well, again, I think we're talking different things. In terms of payment, your alleged onset date, you can go back 1 year from the date of application in SSDI. So you could have an onset date in 2017. And now, and hold that thought for a second, but yeah, you could have an onset 2017, but if you apply in 23, the earliest you can get paid is 22. And by the way, I think when you look at your onset date, one thing to be aware of is the date last insured for SSDI. You want to make sure that your onset date is before your insurance runs out for SSDI. Very, very important because otherwise you're an SSI claim. So if you stop working in 2017, your insurance for SSDI is going to probably run out in 2021, 2022. So you want to make sure your onset date's before that so that you are insured for disability purposes. Otherwise, if you have an onset date after you were last insured, then you're not going to get SSDI. It's like, filing an insurance claim after your premiums, you stop paying your premiums. You got to make sure that you have insurance status, you're fully insured as of your onset date. And I think that the other thing I would tell you is, if I have a case where the onset date claimed is 2017, 2015, I'm going to look to see where could I amend that to make the judge's life easier. If it doesn't make any difference in terms of the money, meaning that I can go, as long as my onset is 18 months or more prior to the date of application, assuming no date less insured problem, then I'm going to move it to that date because that means the judge has to do less work. For a judge to find you approved and go back to 2017, they got to look at records going back to 2017, which may not exist or they may be sporadic, or not real detailed. So yeah, I think that would be a situation you might want to change the onset date if you can possibly do it. The other thing is that when you go back that far, 5, 6, 7 years, the records many times don't exist, can't get them. Or people have gone back to work. I've had people say to me, well, I was diagnosed with a herniated disc or with diabetes or with, lupus or whatever it was back in 2017. I'm going to use that as my onset date. But they worked for 4 years after that. They didn't stop working until 2022. You want to make your onset date when you stop working, generally speaking. Again, to clarify, you can get paid 1 year prior to the date of application. And one more just exception to the rule is, in rare circumstances, if you had applied before and you got denied but didn't appeal it, you can ask the judge, if it's within a year of that denial, you can ask the judge to reopen a prior application. There's a very unique circumstance they can do it within 4 years. That doesn't happen hardly at all, but 1 year I see it happen fairly frequently. So if you had previously applied for disability you might be able to reopen and push that date back so you get more back past due benefits. Terry says, been in front of the ALJ twice. First time denied, went to federal court, remand, second hearing denied again. It's been about 3 years. So you've been dealing with this for, 3+ years. If it gets sent back again, it'll go to a different judge. And people ask me this, I get this question every week, is if the appeals council of the district court remands my case, remand meaning sends it back for another hearing, is it likely the judge will approve me? And the answer is maybe. Some judges kind of, depending on what the appeals council or district court wrote, they may be sort of sending a signal to the judge, approve this person. Because they theoretically can do that. They don't almost ever never do it. But they can issue an approval. They usually just remand it back. So my point would be that some judges feel like, okay, if the appeals council, or especially the district court, felt that this case is worthy of being, remanded back, then they're doing it for a reason. I should give this person a real close look. Other judges are like, I don't care what the appeals council or district court said. I'm going to run my court the way I want to run it. But I think if you have to appeal it again, it'll go to a different judge. Certainly, I would ask for it to be go to a different judge. You don't want the same judge. Joel says, how the work insurance or family medical leave affects or favor SDA claims. Okay, not sure what how the work insurance is. So maybe, Joel, you could explain how the work insurance is. I don't know what that means. Family medical leave, I see that a good bit. That is a federal law that says that under certain circumstances, you can take unpaid leave, for your own medical issues or a family member's medical issues. And family medical leave, if you go out on family medical leave or FMLA, and you don't come back, the onset date you would be using would be the date you last worked. So you would not, in other words, even if you're still getting paid, the issue in a disability case is when you last were able to work. So let's say that you stop going into the office. It keeps re-engaging. I'm going to see if I can turn it all the way off. I'm going over here and clicking off to the tracking for the webcam. So let's say that you February 1st, you went on a family medical leave and you never came back to work. February 1 would be the onset date. Even if you got paid for February, March, and April, and you're paid a full salary, that's not income earned from work. Therefore, it would not count, and you could go back to the February onset date. So family medical leave is just an evidence of you're unable to work, probably by your own choice. I think you have to have a doctor sign off on it, but it's not the same level of scrutiny as Social Security, but it does send a signal that, there is a problem here, that you could not work or you're not able to work. So I think that is helpful. It also shows, in my view, that you are credible, that you went on family medical leave with the idea that you wanted to come back, as opposed to I'm going out on disability. So I think it really can enhance your credibility. And again, I don't know how the work insurances are, Joel, so I'm going to pass on that one. Okay. St. Louis says, what are the criteria used to determine or deem that a claimant cannot tolerate having a supervisor? Does a person a significant documentation they resent even having a supervisor through write-up? So what St. Louis is getting at is, in some psychological evaluations, there could be a finding that this hypothetical person or this claimant, has a great deal of difficulty taking, requests or orders from supervisors. And maybe because of PTSD issues, maybe it was a supervisor had abused that person, whatever the case may be. A limitation that the judge might impose in the hypothetical question is this person would have minimal contact with the supervisor. I think that every job, there will be an expectation that you will have some contact with the supervisor. But I think that, there are jobs where your contact with the supervisor is extremely minimal. So, having that limitation, unless it says no contact with supervisors, minimal contact, there are probably enough jobs to be, substantial number of jobs in the national economy. But obviously most jobs do not have this limitation of minimal contact with supervisors. So the job, what they call the job base, would be greatly reduced. And if you had something else in addition to that, you could probably get rid of that particular job. So, I think that does, the answer I'm giving you, St. Louis, is that a limitation of not being able to interact or have communication with a supervisor is a very significant limitation that is one that very well may prevent many, many jobs, although I don't think all. Jenny Jo says, thanks again for your help. My pleasure, Jenny Jo. Am I taking questions? Asked Jason. Yes, I'm taking questions. If so, what's the rule regarding if $2,000 or less in a bank account by the time the next stability checks come in? That is an SSI issue. That is not an SSDI issue. So if you're on SSI, it is a means-tested program. You're only allowed to have, I think it's $2,000 of liquid assets, but it does not count a house and a car, if I'm not mistaken. Then you have the other household income, from friends or family, things like that, which can also offset it. But basically, any calendar month, if you're an SSI claimant, you have more than $2,000 in the bank, you don't get your SSI for that month. That means you're not disabled, just you won't get your payment for that month. So that's the reason, by the way, that when you win an SSI case and they send out the lump sum payment, it's done over, it's like every 9 months. They don't do it all at once, because if you got a big chunk of money, say $30,000, that would be a problem, for income and resource review for SSDI. For SSI, so that with SSI, having the assets in a particular calendar month would be a problem. So let's say that you had, ridiculous example, $2,001 in cash on, September 1. You don't get paid for September. On August 1, you spent $15 or $20. Now you have $1,995. Then you get your SSI payment. It's that cut and dry. Can the VA get records from SSA? I don't know. That's a very, very good question. I don't know. Honestly, I do not know. I would think that they are both federal agencies, but I don't know if they how well they communicate with each other or what they do. I just don't know. But I'm guessing that the VA, although, I don't know that I've ever seen VA Social Security records in a VA file. I don't know why they would do that, but I think they possibly could. GC Styles, can a person on SSI work on SGA and gain enough credits to become SSI eligible? Let me just say this. I don't deal with SSI a whole heck of a lot. I don't know that the SSI earnings limits are different, and I just don't know how that all works because I don't really deal with it. Let's just see if I can run some real quick. Monthly earnings limits. It says 1900s. Rather than guess, I don't know. I just do not know. I think that might be a question that Greg Brinkley could answer. Greg, Greg at gregbrinkley.org, Brinkley. He would know that. I just don't know. I apologize. I just do not know because I don't deal with SSI hardly at all. Dwayne, can the ALJ offer you a reduced back pay for approval? Well, they don't do it that crudely. What they do is they say, I'm prepared to find you disabled if you're agreeing to amend your onset date to September 1, 2023. So you've got to decide, are you willing to trade off all the past due benefits, for the year and a half before then to get a fully favorable decision? Or maybe the judge says in September of 24, I'll approve you if you amend your onset date to July of 24. That's a pretty crappy thing for a judge to do because basically, especially if there's an attorney, because he knows the attorney will not get paid, but some judges will do it anyway. And of course, sometimes the medical evidence might support that. The person turns 55, in June of 2024, you could see why a judge might do that. But I think that you know they're not gonna say, well, we're not gonna pay you, instead of your monthly benefit being $1,400 a month, we're gonna pay you at a $1,000 a month rate for your past due benefits. They don't do that. They don't bargain with you in that regard. But they might throw out a different onset date, and you have to decide whether you want to go with that or not. Okay. Johnny says, can you disability if you have diverticulitis? You can. And again, diverticulitis is where they're like packets of tissue in your intestine that become inflamed, infected, food gets stuck in them. And if it's a serious condition, you don't want a diagnosis, but if it's serious and it causes significant look at that. Wow, that was interesting. I don't know I tell you, this thing's got a mind of its own. I don't really know why this is doing that. I don't know what I did. I must have done something. I don't know. I have no idea. So you get to see my whole office here, which is kind of a mess. But I don't really know what. Let's see. I don't know. All these buttons here, I don't know what they do. That one doesn't work. So let me go to the other camera, and then I will see if I can fix this one here. So I'm going to outsmart this thing because I got other cameras. So let's try this one here. There we go. And I'm over here, and I'm going to go ahead and see if I can fix this one here and get this one back to where I want it to be. Ooh, that was too far. So, okay. I like this new one because I think it gives me a little clearer picture here. So let's go back now to the Insta camera. There we go. Okay. I'm not sure what the heck I did before there. Who knows? But yes, Johnny, you can get disability if you have a diverticulitis, but it's got to be significant and severe. Oh, okay, cool. Thank you, Michelle. I really appreciate your kind words. Okay, so yeah, I think that there's a lot of good information out there. I try to put as much as I can out there. So I'm glad that you found this useful. Thank you very much for your kind words. And I put here the link to leave a review. Somebody left me a really bad review the other day. I don't know who it was. It just didn't make any sense. They basically said that I wasn't filing appeals, and I don't know what they were talking about because I file appeals all the time. But so I got a bad one, which honestly, from my perspective, it's not the end of the world to have one bad review because it shows that the reviews are real. They're not all made up. But somebody left me a bad one, so if you guys would be so kind as to leave me some good ones, that'll kind of dilute that one. But again, I don't know what this person was upset about, but whatever. Okay. You are very welcome, Michelle. You're very welcome. Okay. If a disability lawyer tells you to call 211 or social services or church for help with money, I asked if it was she I was talking to, if she ever heard of Cal. And she says no. I do not have any idea what you're asking. I apologize. Lost for words, confiding. Oh, compassionate allowance. Compassionate allowance. Okay. And if a disability lawyer has not heard of compassionate allowance, then you got to keep looking because they should know about a compassionate allowance. And I think I've said this before. I have people reach out to me sometimes that have pancreatic cancer stage 4. Okay. It's unfortunately not going to end well. And, would you be my lawyer? I'm like, just apply. Here's what you say. Here's the compassionate allowance section. You don't need me to do this for you. There's no reason to pay me, any part of your past due benefits if you have a compassionate allowance. Some people say, well, do it anyway. There may be a month or two of past due benefits. I want to have somebody, answers help me with this. Fine. But I'll discourage them from having a lawyer. They don't really need it. So my point is, if you have a compassionate allowance level case, you may not need a lawyer at all. I just don't know that it's really all that necessary, as long as you point out the specific compassionate allowance number and let the adjudicator know. And many times, if you do get a lawyer, by the way, and the 5-month waiting period, there may not be any past due benefits, may not cost you anything anyway. So why could they file compassionate allowance? But if you're talking to a law firm that doesn't understand compassionate allowance, you might want to keep looking. That's not a good sign. Okay. All right. So see, I think that's what Cal's compassionate allowance. Okay. Yeah. Cancer Booty talks about that. I think Deb, this is what the attorney said, not what Social Security said. If Social Security didn't know that's a bigger problem. No, it's not short-term disability. Compassionate allowance, I'll show you, is let's go, let me share the screen so you can see it. It is a website Social Security has. It's a way to quickly identify diseases and medical conditions that by definition meet a listing, okay? Cancers, brain disorders, rare disorders. It helps them reduce waiting time to reach a disability determination. And so what it basically means is that they recognize that certain conditions are not going to get better. They're very severe. They're going to limit your functioning, and you should be approved quickly. So they list, there's a whole list of them here. And so let's take non-Hodgkin's lymphoma. So you'll see here, there is a number, this DI, in this case, let me make this a little bit bigger so you can see it. DI 23022-921. That is adult non-Hodgkin's lymphoma. And they talk about you need an MRI or CT or blood chemistry, what the diagnostic criteria would be. It's treated with chemotherapy, radiation, et cetera, et cetera. And then they'll say, this is the listing that this compassionate allowance is associated with, a cancer listing, the neoplastic listing. So basically they're saying is that if you have a compassionate allowance level condition, it meets the listing. Clearly, you get approved quickly. That's what the compassionate allowance does. So it's not short-term disability. It's just an expedited approval procedure. Okay. How active should attorney challenges the VE opinion number of jobs? Okay. All right. St. Louis is asking, let me stop the sharing here. How active the attorney be in challenging the VE's opinion the number of jobs? And what he's getting at is at the hearing, the judge will ask the vocational witness to identify jobs, then say how many jobs exist in the economy. The problem is there are no really accurate references for that. There is, I think it's SOOC, I can't remember the acronym. There are newer things than the Dictionary of Occupational Titles. The problem is a lot of these, let's see here, a lot of these resources are going to have more than one DOT title to them. So that means that the vocational witness is going to have to kind of estimate the number of jobs. There are some lawyers who believe that an attack on the VE's methodology and numbers can be a way to discredit the VE and win cases. I'm not one of those, but I don't disagree that VEs can sometimes come up with ridiculous job numbers. I think you might want to take that up on appeal, but there are lawyers who believe very strongly to go after the VE. My experience, and I'm speaking only for myself, is judges don't like it when you go after the VE really hard. But if you have a ridiculous VE who's coming up with all kind of crazy numbers, I think it's fair game to ask how they came up with those numbers. Have they ever actually placed somebody with these conditions? But if they came up with 135,741, where did that come from? Well, they may have divided some other number to get that, and that's not an accurate way to do it. So I'll give you an example. Let's say that there are 4 jobs that that a particular let's say there are 4 jobs that are fairly similar, And one of those jobs has a limitation where you would not be interacting with coworkers or supervisors, not climbing ladders. The other jobs, everything else about them is the same. And there are 1,000 jobs, make the math easy. There are 1,000 jobs in these four categories. It is not followed that 250 of them would be in this more limited subset of those jobs. Some vocational experts will just divide by four, as opposed to looking at it and saying, well, this subset is, there are much fewer jobs. There may only be, instead of 250, there only may be 25, which is not substantial numbers of jobs. Therefore, it wouldn't hurt your case. So that is one way to go after the VE, is to ask how they came up with a number. If they interpreted it or interpolated it from something larger, that can be grounds to object to it. But again, I see that more on the appeals side as opposed to the hearing side. But some of my colleagues will go after the VEs in that regard. Yeah, it took 4 years. I just had a case, excuse me, I tried yesterday, and the guy applied in 2020. So he's been waiting 4 years as well. Hopefully it will be approved. I mean, it should be, but who knows? And Michelle, is there any short-term? There is no short-term disability through SSA. It's either you're disabled or you're not, but it's not going to be for a limited amount of time. It's indefinite until you're terminated. What should you do if one of your doctors does not believe you're disabled? You have a lawyer. Well, I mean, the obvious thing is get another doctor. That's one thing. If you can't do that, then your lawyer is going to have to really work to, discredit the doctor's opinion. Now, the doctor may have observations and treatment, but, may say very clearly in the record, I think this person could return to work. You could go after the doctor's opinion, in a brief, by noting that the doctor is not a vocational expert, does not know what employers will tolerate. And his opinion or her opinion about your capacity for work is no different than a layperson's. That would be one way to do it. You could object to any reference to vocational capacity in the doctor's records, because again, the doctor is not trained. You could get your own vocational assessment from another doctor and say, we have two conflicting ones. Judge, we feel ours is more credible. So that's sort of how you would deal with it. I think Michelle says find another doctor. That not always possible, but that is certainly a good thing. What do I think of the pickleball? Okay, here's an off-topic question, but okay. See, pickleball is the equivalent of wiffle ball compared to baseball. Parked in my home, the equivalent of tennis course, the pickleball court. Okay, this is not about disabilities, it's about pickleball. I played pickleball. It's fun. I think pickleball was originally designed for people that are a little bit older, didn't have to move as much, and then more recently, the last few years, younger people have gotten involved in it. And if you see people in their 20s and 30s playing, they're hitting the ball really, really hard. Personally for me, I like tennis because it's more exercise, it's more running around. I think pickleball, you're bent over, so I think it puts more strain in your back, puts more strain in your Achilles, a lot of stopping and starting. It's a fun game. It goes quickly. You can play at any level, but it's certainly, in my opinion, not as aerobic as tennis unless you're playing at a really, really high level. And I think it's here to stay. I think it's there's also, I was at my wife's match, and there's something at this place, there's something called paddle, P-A-D-E-L, paddle ball. It's an enclosed, looks like a small, I did the thing again here with the follow. It's an enclosed space, like with plexiglass walls, and they use kind of a modified tennis ball, but like a flat sort of racquetball, pickleball kind of not really a racket. I guess I could call it a racket, a paddle, whatever. And you whack the ball, and you could kind of like racquetball was in the day. You can go off the back sides. So it's kind of a variant of pickleball. But I think pickleball is, it's fun. You can find people at any level to play it. You want to make sure you stretch out your Achilles and you don't have back problems. But it's fun, very social, and it's the hot thing right now. But for me, as long as I can play tennis, I'm going to play tennis. Because I moved from basketball to tennis. I played basketball up until COVID, 2020 in men's league, which I'd done for years and years and years. I was playing with people that were 20 years younger than me. I obviously lost the speed, but I could still shoot. Now I'm 6'1", so my league I was fairly tall. So I went from basketball, but once you get out of basketball shape, it took away. It was too hard on the body, too much pounding. And tennis is to me much easier, not as physically demanding. Muley says, what does it mean when SSDI canceled your consultative evaluations? Is that a good thing? Yeah, I think that's usually a pretty good thing. That's been my experience. If they're canceling, it means they are, probably going to approve you. All right. St. Louis says pickleball is more accessible. Yes, it can be. Absolutely can be. Again, it's, I would say if you're able to try it, try them both. Try them both. Let's see here. Case evaluation, I got that there too. And Michelle says that they did, they canceled her evaluations as well. And that's, again, usually a pretty good sign. I had case taken to federal court by falsifying documents. That's very unusual. I mean, I think that what obviously seems to have happened here was that somebody in Social Security did something improper, and that the judge basically, judges in the appeals level, they can grant a case, which means they can actually pay it, or they can remand it back. Usually they remand it back, but every once in a while, if something was clearly, wrong, there's something falsified here, whatever, they can actually go ahead and grant your case. And that may be what happened. That's pretty darn rare. Thank you very much. Nice. That was very nice. Big pardon. No problem at all. If SSDI turns retirement, I don't want SSI, I can refuse it. Yeah, I don't know you're going to get SSDI is going to turn into retirement. It doesn't turn into SSI. So you'll have SSDI, which is treated very much like retirement Social Security. And, if you live in a different country, you can get that, where I think you can't if you're getting SSI. So, if you don't want SSI, yes, you can refuse it. Absolutely. I believe I never, time I do it, I just, usually it offsets, but. And Michelle's point about the doctor doesn't believe in disability, yeah, that could be a problem in your case. Some judges look at the medical report and the doctor's like, doesn't believe in the concept of disability and therefore won't find you, the limitations that would disable you. That can be a real problem. Thank you very much, Rodney. Susan is another attorney in my office that we've been working together for many, many years, and I've been teaching her slowly but surely. She's I think she knows enough now to, really not need me so much anymore. But she actually tried Rodney's case, and we won before one of, if not the most difficult judge in the Atlanta area, and she won. So good for Susan, and even better for Rodney. Okay, Michelle's point was that she had neuropathy in both feet, surgery. The judge was even apologetic that it took so long. Yeah, and some judges, they have no control over how long it takes at the administrative level. But I've had enough judges tell me, like, I cannot believe that your client's been sitting there for all this time, why they didn't approve it before. So yeah, judges are people. They will absolutely offer their opinion. Thank you, St. Louis. I appreciate the $5 very much. That will buy, I take these tips, which I really appreciate. And, maybe we'll buy lunch for the office, the staff in the office, or, maybe I'll take my son out to lunch, or my daughter. And, so I really appreciate it. It's a very nice gesture. Severe mental health problems plus eczema. Does eczema enhance the time away from work? Regular scratching. Yeah, I've had a couple of cases with eczema, with with psoriasis, things like that. And it can be a contributing factor to disability. It can limit, for example, a judge might impose, climate limitations, extreme heat or moisture. or dryness or something like that. So that could eliminate categories of jobs. There could be limited interaction with the public. That could eliminate categories of jobs. I think that if the itching is extremely severe and you're taking time away from work and you can document that you're taking, out of an average hour that, the scratching is taking up 10 to 15 minutes and taking you off task, that is a real problem. So yeah, I think that, the mental health problems plus eczema, if you can quantify it, and that's a really important point to make. You have to quantify it. It's not just it happens a lot. I would even tell you, St. Louis, to keep a diary of how often you have episodes where you are, scratching nonstop, cannot control the itch, for, 45 minutes at a time. And then, during the course of a day, this happens twice. And you have a diary and you show over a long period of time, over the 2 years you're waiting, that this happened on a fairly regular basis. That can be pretty compelling evidence. Really could be. Michelle has fibro. Wow, it's a hard road, but I think you have some other things that would certainly support your win, the neuropathy and so forth. Andre just got an approval. Good for you, Andre. How long to get your check? Figure 3 weeks maybe for the check and the back pay. Hey, Madeline. Madeline works with me as a legal assistant, call screener, and whatever else we give her to do, because Madeline gets stuff done really quickly. So she's a really valuable member of my team, and I'm glad you are here. Thanks, Madeline. Hello. And Madeline it's interesting, like I mentioned before, my staff is mostly remote, so we're all over. So Madeline, I think you in Oklahoma? I think she's in Oklahoma. I'm in Atlanta. Jen is in Nebraska. Stephanie's in Florida. I mean, everybody's all over. So that's the amazing thing about the internet now. St. Louis knew of a veteran who won a fibro claim with PTSD. I've won fibro claims. I've won plenty of them. It's just hard. It's really, really hard. They're just very, very difficult to win. All right, Michelle makes a good point. After you're approved, you want to, keep going to the doctor, because Social Security will ask you in, the short form and the long form, have you gone to the doctor? So, you don't want to stop going to the doctor, because what does that suggest? That you're only going to the doctor before to get on disability. So you don't really want that. What about the news coming up, putting us back to work? Can you cover that news? I don't know I had not heard that news. Every once in a while, some politician floats the idea of, cutting off disability or reducing it. They get their high horse and talk about the fraud and all this stuff. It hasn't happened. It's not going to happen. That's my opinion. Ticket to work. The ticket to work is something very different. That is, and I don't know much about it, honestly. That's probably more of a Greg Brinkley question, but I believe it's kind of it's a way where, you get, you go through some training and you get something literally called a ticket, and you take it to work, and, you get a job, and they don't cut your benefits off for a period of time to see whether it's going to work. It's designed to get people back in the workforce. So there may be some proposals about increasing or enhancing the ticket to work program. That may be what you're talking about there. SSI, as of the date of application, you don't get benefits before then. So if you applied on September 15th, you can't get paid for June or July or August. It's as of the date of application. Irvin, I'm 63 years old and full medical view at 55 past not expected. Irvin's asking about getting a medical review or CDR. I'm not going to say it could never happen, but it's really unlikely if you're 63, because you're really close to retirement age. And, if you were found disabled at 55, okay, then at 63, unless something significantly has changed for the better, it's easier to win at 63 than it would be at 55, because there's this whole transferable skills analysis that, it's harder to prove transferable skills for Social Security to prove it as of when you're after 55. So at 60, Basically they have to prove you could do your past work, which if you couldn't do that, then you win. But I would say that the odds of a full review, unless there are earnings, the big caveat is, does somehow Social Security see that you've been working their earnings? Assuming there's no earnings, the odds of being reviewed again are pretty low. Andre, congrats that they try to break those payments. So this may be an SSI issue that they break up. They don't break up SSDI. And I think what Michelle is saying is that she was able to get them to release the money because they had a need. Okay. Christina, I missed you, Christina. You're normally the first one on. But hello to you from California. Hello to you in California. Okay, so Michelle's daughter with special needs, that her father passed away. He was on SSDI, and she became eligible as a disabled adult child. That's what's going on there. That's a different program, and it really says that if you became disabled, I think it's prior to 18, I don't remember exactly, and you have a parent on disability or eligible for disability, you can claim disability as a disabled adult child of that parent. Thank you very much. My pleasure. Nice. Main event. How are you doing, main event? Christina with the reminder. Thank you very much. How long after back pain and stopping work should someone wait before hiring an attorney to apply for SSDI? Two-part answer to this. I think, some people want to just apply on their own, ssa.gov/apply for disability. There's really no harm in doing that. If you win, you don't pay anybody, you get your money and you move on. I will tell you that back pain is the least likely thing to get approved early. So, I don't think you're taking a great risk by hiring a lawyer. I talked to a new client today. I always give them, when I talk to somebody, I'm like, look, you could do this on your own. I can show you where to go. Maybe you win, and at that point, you don't need to worry about paying a lawyer. You get your 100% of your past due benefit, as opposed to giving up 25%. It's limited, but 25% of past due benefits. This person said to me, look, I am really uncomfortable. I've got a significant medical problem. It would be helpful to have somebody do this correctly and then to be able to help me with the forms they're going to send me, which is what we do. So I can understand that argument as well. Thank you, Calvin. I will make sure Ginger, I think she said she had a school program tonight for one of her kids, but normally she's here. Okay, so the VA records, St. Louis says the VA can get records. I think you mean from Social Security. And in fact, it says that they're required to do that. So I'll accept that. I don't know. I should redo something about the yearly COLA. I'm not keeping up with the times. The VA can get records from SSI. Yeah, I think they can. They'll give you and I don't do VA work, but I know they give you the release and they can get it from any place. I'm not SC. I don't know. I've not known anything about it. I'll see if I can find out about it for next time, but I don't know. We'll be filing a disabled adult child for my disabled son when I turn 62 and therefore become eligible for Social Security and fill my own retirement. If they take 6 to 12 months to approve it, will they back pay the day I turn 62 and file? Well, you're going to, yes, as soon as you become eligible or your child becomes eligible for disabled adult child, then that's the start date of the benefit. And at that point, you would be, your child will be paid. And again, the eligibility for disabled adult child is you've got to have a parent who's receiving some form of Social Security, including retirement. How long does it take to get retro pay? 3 to 5 weeks. I gave 5 to 6 different reasons why I can't work. Does not actually work against me. I thought that might get done for somebody can approve something else. Personally, I usually will list 3, maybe 4 reasons. If there's a reason to list 6, sure. But, I wouldn't put like sleep apnea on there. I wouldn't put, there's just certain conditions that, fibromyalgia that you were never formally diagnosed with through the American College of Rheumatology. Um, so, I, I don't know that I would list some of the more minor things, you know, but the major stuff, three or four, in my opinion, is probably a good sweet spot. Let's see, if I'm granted SSD and I have a kid, I think it would go in your SSDI as an audit as a auxiliary. It'd probably be more money than SSI. Ah, who this is? Thank you very much. Took another several months to win the case. Okay, well that's the goal. That is the goal. And I appreciate your kind words. Thank you very much. When I take over an application, start with a different attorney, not mad, but completely MIA, doing everything myself anyway in New York. Um, Only way I do that would be if the prior attorney will withdraw and waive fees, because otherwise there's no way for me to get paid. You have to do a fee petition, and they just ignore those. So if the prior attorney, first of all, I would say try to work it out. Contact the law firm and say, look, I'm getting really frustrated. No one's calling me back. I need a phone call from somebody who can talk to me, or at least a detailed email, something. If they will not do that, say, look, if you're not interested in my case, will you withdraw and waive fees so I can get another lawyer? And there's a form called the 1696 Sept 2. Excuse me, I will show you that. And let's see here. Let's see if this is low. Okay, I'll just show you this. 1696 Sept 2. So if you want to get another attorney, and you already had one, this is what you would need to get the first attorney to fill out. It's the 1696, which is the appointment representative form. The Sept 2 is the supplement, and basically the representative's withdrawal and waiver of appointment, and then it asks, are you going to waive your fee or are you going to seek a fee? So if the prior attorney will click this button here saying I was seeking a fee, but I will not, and they withdraw, then you can get another attorney to take it over. If you can't get that, it's going to be hard to find a lawyer to take it over because nobody wants to work for free. Okay. Matt is in Orange County, New York. I never heard of that. Okay. Michelle did not hear from her lawyer until a week before court. That's not ideal. Not ideal. But I will tell you, to be absolutely fair, things happen very slowly in the Social Security disability world. And, legal fees are fixed. So, you're not going to, I think if you expect to get a phone call every week or every 2 weeks from your lawyer, that's probably not going to happen. And that's not unreasonable. I think you should be getting, email. Your lawyer should be able to respond to you by email or have someone in the staff call you or email you to explain what's going on. But I wouldn't be upset that your lawyer, him or herself, does not call you every month because, if these cases take, 2.5 years, 30 months, it's just not practical to call somebody every week to say there's nothing new. Sharon was denied for disability, applied for SSI. Will this take long? Applied June 17th. So you're denied for SSDI, now you've applied for SSI. You'll probably end up getting a decision in maybe February or March, is my guess, because it takes a long time. Everything in order. Gator says, my case was denied by the ALJ, is now in the ACE Appeals Council. How long will it take to get a decision? 12 to 18 months. Your past benefits do continue to accrue. That seems a little long for the Appeals Council. I would say probably 8 to 12 months. Okay. Dana has been on disability since I don't know, was 43, not expecting to improve, passed the full medical review of 7 years, 63. I think I've answered this before. Probably not, Dana. Probably not get another, form to fill out. Jamir, Appeals Council remanded to the ALJ stating further consideration should be given to whether or not fibromyalgia is medically determinable impairment. That's unusual because, fibromyalgia is recognized by Social Security as a legitimate condition. Whether it is a medically determinable impairment is going to depend to some degree on the diagnosis, the qualifications of the person making the diagnosis, and the practical impact on you. So, if the judge, did not, give any weight at all to fibromyalgia complaints, the appeals council may be saying to him, you need to do so. Okay. About a year and a half ago, I filed for a Social Security bill. I've been waiting, and I need help. I would tell you if it's a year and a half, you might want to get on the phone to your U.S. senator because that's way too long, way too long. 2014, I said, only if you applied in 2015 or 2014. If you applied in 23, you're not going to get 10 years of back pay. That's a very good question. Why can't you change your judge? So you lose the ALJ level, you file an appeal to the appeals council. The appeals council remands it back to the same judge who denied you the first time. Kind of ridiculous in my opinion. But that's their procedure. There's nothing you can really do about it unless you can show extreme bias and prejudice. Okay. Jeff filed for disability a year and a half ago, filed for SSI. They called today and tells you to put it on hold because the case is in medical appeal. So but yet I'm told, this whole time this is a separate SSI, but yet suddenly affect one another, how the hell I still need help. If you file, first of all, the same people doing the adjudication, same definition of disability. So if you file for SSI only, now it looks like you had a pending SSDI case and then you file for SSI. What I would do is ask them to consolidate the two claims so you're treating them both together. Magical Indigo. Question of some type. Let's see what we got. John had diverticulitis surgery with a fistula surgery, very painful. Well, this was 10 years ago, and I was still issued my stomach, just applied. If you think about it, if you had a surgery or a condition diagnosed, serious condition 10 years ago, and you're able to live through it, you're going to have to explain to Social Security or a judge why you can no longer live through it. And age alone could be it. There could be some form of complication. I don't know. But if you're able to work for those 9.5 to 10 years, then by definition, you were not disabled during that time that you were working, or that, you could work. So it's going to just really depend on what the medical record says about your capacity to work now. So what question mark? You like, what's that famous who's on first, what's on third, or something like that? Bad joke. Abbott and Costello. If you're not sure what that is, look up Abbott and Costello, who's on first. It's very entertaining. Yes, tennis is a good sport. A hearing with the ALJ on July 25th of 24. How long for decision? Anywhere from, it's been 6 weeks. I'd say give it another 2 to 4 weeks before starting to make noise. Hey, David. Yes, I was just working on your file the other day, as a matter of fact. So I see your communication through the portal, but I'm glad that you tuned in. Thank you very much. Magical Indigo. My lawyer says I get denied because they don't want to pay retroactive. Um, you know, Magical Indigo, you're getting into legal advice, which I don't feel comfortable doing on a YouTube live stream. I think if you've got a lawyer, talk to your lawyer about the odds of appealing. Jim is in a gray area. Getting full knee replacement in December. I can't work construction. Do the pain VA told you to file, but EDD, vet rep, VA continued assistance while waiting it. EDD is not the California disability program, I think. Again, Social Security doesn't provide temporary relief. As far as what to get, how to get some assistance while you're waiting for Social Security to evaluate your case, that's unfortunately beyond my portfolio. I don't know. St. Louis Grant says, if you have a Portillo's restaurant in your area, recommend it. Okay. I'm not familiar with Portillo. I'm assuming it's Mexican. Let's take a look at. Chicago street food, it says. So I'm looking at I got Charbroiled burgers, hot dogs, beef and sausage, chicken sandwiches and ribs, salads. Looks like some form of pasta, desserts, sides and soup. It doesn't look, it looks good, not particularly healthy, but it looks good. So, sure. Thank you, Dave. I appreciate that. Wondering, John asked, if messaging a specialist, the person deals with epilepsy, to get a medication refill is considered as seeing the specialist. It is, in the sense that you're communicating with the doctor, but it's not the same as going in. I would tell you that if at all possible, try to go in once a year at least, even if you're just going in to just get medications refilled. Because I think if you're at a hearing and the judge says, when's the last time you actually saw your doctor? You can say 4 months ago as opposed to 2.5 years ago. Kevin is 58 years old, bad left knee, denied initial on recon since May. Again, musculoskeletal issues, the most difficult type of things to win. I think that, it's been May since recon, so it's kind of too early to really start complaining to your congressperson. But yeah, it's not unusual there. And I think I would make a grid rule argument. With one bad leg, you're not going to be able to sit or stand very long. And you might meet the grid. So take a look at gridrules.net. I have a question. My ex-brother-in-law died. My sister retirement. That's crazy. Ex-husband. Not sure, Kimmy, what you were asking me. I don't know. Okay. I've had concussions. That's what caused a lot of mental pain. Yeah, concussions will do it. I think that concussion, closed head injury, can create a lot of work preclusive problems. My judge was a fraud judge that won SSDF fraud, and she denied me when I have a big book hospital business. Well, that's why you appeal. That's why you appeal. And it's unfortunate, when you talk about fraud is a legal term. So, was there some sort of action taken against the judge for doing something fraudulent, or you're just upset and you're saying he's a fraud or she's a fraud? You got to be careful about throwing those words around because they have specific legal meaning. Last TBI just messed up my left brain, messed up my vision, eye muscles. Yeah, those sort of things. The concussion you mentioned causes mental pain, blood marker, or looks like blood disease marker, something like that. TBI. Um, yeah, I mean, again, TBI cases, if they're documented, and it can be hard to do sometimes, they can be very, very strong cases because, again, your behavior would not be consistent with competitive work. Um, Possibly. I mean, I think that the conditions, John asks, would I have a good chance to receive disability because of my diverticulitis surgery with IBS? It depends. It depends on how severe the diverticulitis and the IBS is, and was the surgery successful. Um, I think that it just depends on how it's left you. Do you have to use the restroom, 5 times a day, 7 times a day? How long are you in there? Is it painful? Do you have some days when you can't literally get out of bed, or months, or things like that? I think that's really the big question here. Thank you, Christina. Exquisite. I have a 5 to 7 year review. My onset, it was December 2019, 50 years old. Would like to review soon. Um, Probably not great because, you're already 50 and the reviews are not being prioritized right now. That could change in January. We don't know. But right now, I would worry at 50 years old. So you're going to the doctor, you really have nothing to worry about. But I don't think that you'll be reviewed. I'd be surprised. Okay, can I do a video? I probably have done them on those, but I'll add that to the list, and maybe explain what each of those things are. Stenosis, which is a narrowing of the where the spinal cord goes. Herniated disc, where the spongy material cushioning goes out, and spondylolisthesis. They used to call it a slip disc, where the disc is pressing on the nerve. We can talk about all those things and the work applications that arise. I'll put that on my list. Is there a way to look? There probably is. I know that disabilityjudges.com used to do that, but that's kind of outdated at this point. There may be. I did a search on a judge that was not in any of my other resources. Something came up, from about the federal government employee and so forth. So there's lots of things to look up, but um, the the information, like I'll show you disability judges, which again is outdated. This used to be my go-to resource. So let's just say, let's go to I don't know. I think I'm looking at a spreadsheet here. All right, so I'll show you this. This again, I don't know how new this is or how relevant this is, but this is an idea of some of the stuff you can see. All right, this is from disabilityjudges.com/state. So I'll make it a little bit bigger. So let's just look at my home state of Georgia. That's pretty low on the list here. Hmm. Hmm. Okay. Wait times. I was just trying to find something here. It does not show. Let's see if it's got anything in Georgia. Okay, here we go. Okay, so Atlanta downtown has 20. I don't know if that's, it says the average hearing wait time is 15 months, average processing time 539 days. Cases approved 43%. I don't think these are accurate, but this gives you some idea. So there are statistics out there. Whether they are available, and they're accurate, I don't know. But that's one place you can look. This says last updated 4/28 of 23. So take that for what it is. There's a bunch of other places to look, but that's one place I go to. North Carolina. Let's just look and see if there's anything in North Carolina. This says updated 4/28/23. So in the Charlotte office, it says the average hearing wait time is 9 months. Average processing time is 359 days. I guess for the time that you request a hearing to the time the hearing decision is released. The case is approved higher than Georgia, 51% out of Charlotte, and Greensboro is 55%. But Fayetteville is only 47%, and it takes longer too. So again, that's one place to look, is go to disabilityjudges.com, and that tells you information presumably updated through April of 2023. How do I get a donation? There's a button on YouTube. Somebody said to ask us before, there's a button on YouTube. I don't know exactly. Let's see, you're in Raleigh rather. And so this gives you a breakdown of Raleigh, 8 months, and the judges. You can go by, this is, you can see is all zero. So this is really not very helpful. There's other places to get the judges, but Raleigh is, compared to some of the other ones, is 8 months. It's the fastest, so you're probably in a pretty good place if this is still accurate. Someone called me last week. I'm supposed to email their contact so I could send my medical information. Never got it. Not heard anything. Is this from my office, or is this some? I'm going to look you up and see if it is my office, and we'll fix that. Ah, it was. Okay. Probably Madeline. So why don't we do this, Charles? Email me at ssd, and well, you know what I'll do? I'm going to send you an email. You don't have to do that. I can send you an email, and I will tell you. I'm just going to put this. Okay, I'll put Madeline's. Okay, Charles, we are fixing this problem on the fly. Okay, check your email, because you just got an email from me. How about that? How's that? Service with a smile. I'm sorry about the, I'm not sure what happened there. I'm just to see whether somebody dropped the ball or not. Now, I do see Madeline had emailed you. So unless you put the wrong email address in there, she emailed you on September 20th saying, please send me your x-ray notes or recent medical records. So you did get an email from her. I just sent you an email. So if you didn't get that, I want you to go back to that, the SSD Answers site, and fill in another form and just say, please, here's my correct email, because she did send you an email. I'm looking at it right now, and I just sent you one. So if you did, look and see before this is over, let me confirm you got it. How about that? How long for stopping work convictions before we apply? That was my question before. I think that, if you don't think you're going to be able to go back to work, there's no reason to wait at all. I mean, basically, the definition of disability is having a medical problem that prevents you from engaging in substantial gainful activity because of a condition that has lasted or is expected to last 12 consecutive months. So if you stop working, which today is September 25th, you stop working on September 24th, and you have a condition that's going to prevent you from working, apply the next day. No reason to wait. Rebecca says, your mom, who's 59, needs heart surgery, many other issues. Could she apply if she's on leave from work? Yes, she can. But if she goes back to work within a year, that's going to be a problem. But if she thinks she's going to be out of work for at least a year, even if she's still technically employed, she can absolutely go file for disability. Okay. Is it a good idea to bring up a new ailment? I think that it's probably better to do it at the recon, but you know what? If you're talking to a doctor, yeah, bring it up then. There's no reason not to. No, I keep looking at the wrong camera. Let me just close this up here. I don't know why. That's the one I've been looking at for years. And I'm now got a new one, which is better, and I'm more direct, but okay. I got to work on that. I would bring it up to the CE doctor, sure, and bring it up at recon as well. Yeah, I mean, she's missed 20 weeks of work. That's a good case. I mean, she's got heart issues, 59 years old. That's a strong case. I would look at that very closely. Alan says, I'm supposed to have a CDR in August. I said, could the CDR, it could come later. Yes. Yep. Absolutely. Um, Robert says, hello, Robert. I'm at stage 3. Got there within 1 month of filing is a good thing. You were got okay. And Robert, I know I've talked about this before. Um, Stage 3 is sort of a construct that Social Security has to kind of, basically tell you they're working on your file. It means it's moving along. But I don't put a lot of weight on stage 3, stage 4, stage 2. At the end of the day, they're going to process your claim. What they call it is really not particularly relevant to me. So I don't know what that really means. So yeah, I don't know that stage 3 means a whole lot. It's really about the time, I think the time is, um, you know, for initial, it's going to be 8, 9, 10 months. Whether they call it stage 1 or stage 3 or stage 5, it doesn't really matter. Appeals counsel included further claim as bilateral carpal tunnel. Right. So obviously the judge did not talk about your carpal tunnel, and that the appeals counsel is telling the judge consider a Jammer's, a carpal tunnel. Joel, how are you doing, Joel? Enjoy your live chats. Thank you, Joel. Appreciate it. Glad to be here. St. Louis says Portillo's also has plant-based Chicago-style hot dogs. I really, I believe it or not, I'm not I should believe it or not. Every once in a while, a good hot dog is pretty darn good, although they're not very good for you. There's a kind of sausage called a bori. It's like a South African thing, and you can get them in the store. Sometimes butchers make them. Very spicy kind of sausage. Um, you know, Typically beef, but I guess it could be other things as well. I haven't really liked those, the low salt version, because they're really salty. But there's a butcher near me who makes these Borvars, is what they call them. And I mean, these things are deadly. They're just good. I mean, you may, feel sick to your stomach for a week afterwards, but they're really good going in. So I don't know about plant-based, but if I'm gonna eat a hot dog, I'm gonna eat a real hot dog. But that's just me. My wife is kind of not vegetarian, but she's pescatarian, so she would like something like that. She always says you can't tell the difference. I can tell the difference. So that's just my opinion. Jammer says, or Jameer, 4 specialists, my primary flow to RFCs, know what was given. Yeah, I mean, you got a lot of stuff going on. I mean, that's surprising that those would not be, considered by a judge. You may have had a really low paid judge, is what it sounds like. Yes, Robert. They want a copy of your workers' comp stip because workers' comp, the issue about Robert brings up a very good point, is that a lot of times in workers' comp settlements, it will say that you agree not to file for Social Security for a period of time so that you won't burden Medicare with something that was really a workers' comp medical problem. That's why they do that. So that's more of a Medicare issue than Social Security issue. And the stipulation is to show that that you had language in there that basically said that the money you're getting from your settlement represents the expected payout over your lifetime. It's called a Hartman clause most places. That's what they're looking for. So yeah, you got to have that. So make sure you send us a copy as well. I want to take a look at it too. My judge fought a big fraud case, being as by case took the judges to jail in 100 cases. I don't know. I honestly don't know. Some judges, again, just have the attitude that they want to. I mean, let's go back to this disability cases. Let me see if it's still showing up in Georgia. And I'm just going to show. I'm going to show you without comment, so you can draw your own conclusions. Now, so they don't have any statistics anymore, but it used to be you could literally see, Judge A approve. Well, I can show you on this one. Let me pull something up for everybody here. Okay, let me show you. All right, so I use this site, the Atticus site, and you can see that disability judge approval rates can vary drastically. The highest rate was 97%, the lowest rate was 10%. So imagine you have a request a hearing and you get judged 10%, and the guy next door gets judged 97%. That you're not gonna be real happy about it. So I mean, here is just a list of the judges with the highest approval rate. Look, some of these judges, the appeals council may review that because it may seem kind of high, but let's just say you happen to get, this particular judge who's 85%. That's a pretty good sign. That's a pretty good sign. But then what happens if you get, this is a judge in Atlanta who's actually a very nice guy, but you see his approval rate. You get him, not really good. So, in Atlanta, this judge is a 20% rate, but then there may be, let's just go here. Let's see anymore. Okay, well, let's just say you got this judge here who's a 72% approval rate in the same hearing office. It can be really frustrating. I'll leave it at that. You are very welcome. Don't remember some workers' comp who would affect. You know what, Robert? Let's do this. Give me a copy of your stipulation, and we'll talk about it. So yeah, we'll just let me see it. Donation button is the bottom of the screen. Okay, again, I'm not looking at the YouTube screen. I guess I could go there here, but it'll start playing. I don't want to do that, so I'm not gonna mess with that. Thank you, Christina. Yes, please. That would be much appreciated. Let me see if I can put that little link on here. Yep, there we go. Okay. Okay, so Charles, you did get my email. So, okay, so just email me back. Teresa says, cannot hear me good. Okay, anybody else having that problem? I got the microphone literally right here. So I'll move it up. Unless the battery's going dead on the mic. Okay, there we go. My award letter saying I could be reviewed in 5 to 7 years. Are they going to do it in 62? Probably not. I've been trying to reach out to Jen. I will make sure that either Jen or I contact you. In fact, let me do this. I try to put all of my new clients in my my database here. Let's see. I don't have. It's going to be. I don't want to enter you, then have to email you. All right, but I will make a note right here to email you after the live stream so we can get you taken care of. Okay. Sabrina says, is there a permanent penalty for drawing early Social Security while waiting for disability approval? No penalty. The real issue there is that if you draw early retirement Social Security, and you lose your disability case, which usually you're not going to, but if you lose it, you're grandfathered and you're stuck at that lower rate. If you draw early retirement and you win, then you're bumped up to the full retirement amount. So there's no penalty other than you could be stuck if you lose. Okay, she says Yahoo. Okay, we'll make sure. I'll change that. In fact, I will change that. I'll just write, Charles, I will change it. If you would just email me back with the email you want me to use, I'll change it in our system. Therefore, the Yahoo. It's probably what you used when you contacted us. In fact, let me take a look. Yes, you gave me a Yahoo address. So that's probably what she used. But I'll change it. But I'm not going to obviously announce it on here. Just email me back and I'll change it if you've not already done so. Okay. All right. Aaron says, why would they order a psych assessment when you don't have a mental problem used to validate your now? Typically, no. I mean, I think that, many times the adjudicators, um, they may see some reference to depression or anxiety in the medical record, and they may, at that point, order a psych CE, or they may just decide they do it in all cases. I don't know. But I don't think it's used to deny a case. Typically, the psych CEs are actually helpful more often than not, more so than the physical medicine ones. Again, Dawn, I don't know that stage 3 means a whole lot. It's just the full amount of time. Yeah. I was thinking I have previous injuries, oldest L1 compression factor. Joel, when you apply for disability, and let's say it's an orthopedic problem, you probably want to have a current MRI to show what's going on now. Believe it or not, in the back, even disc herniations can sometimes improve just with time. So, I would not rely on a 5-year-old MRI. Good question, T Cash. Why does they not count the first 5 months, the 5-month waiting period? There is no reason other than they don't want to pay you. There's no reason. Okay, so 50, yeah, that's good. So that 50% is pretty good. I can live with that. Hey, Tara, how are you doing? Okay. So to pick on you, some judges, even the higher paid judges, some of them are skeptical of depression cases. They may push you a little bit on it. Doesn't mean, but again, it's just every judge has a different view. Okay, well, they will use the grid rules. The light grid rules are going to apply from 55 on. So if you go to gridrules.net, let's go there here. And we're getting close, by the way. We got about 5-10 more minutes here. All right, so whether at 55 or 60, if you go to the light grid rules, you'll see that at 55, a lot of the categories you can be disabled. So if you're 55 and you have high school graduate, I went a lot on 202.06. High school grad or more, not transferable skills, you're disabled. So at 55 or 60, it's going to be the same grid rule. The difference is that there's a more restrictive notion of transferable skills. It's harder to prove it after 60. Social Security has a bigger burden, so it's easier to win at 60 because it's harder to find transferable skills. And if you look here, transferable skills are are important factors. So, you could be age 60 and it's going to be easier to meet 202.06. It may be a slight difference, but it's slightly easier. Okay. Joel says a 2.5, also 300-pound door fell on you with these, including my case. Yeah, absolutely. So you've got 70% disability rating. Yeah, I think that's probably not something that, there's going to be some residual effect of that. So yeah, that would be something. Okay. St. Louis Grand says, yeah, sometimes it just could be your connection. Okay, good. Glad y'all hear me. Good. Okay. Okay, yeah, I hope I hope your appeal does get, Aaron, it is possible to fire a disability lawyer, but proceed carefully because I mentioned this before. If you don't get the prior attorney to withdraw and waive fees, you're going to have a really hard time getting a new attorney to take your case. Because to make a very long story short, if there's been more than one attorney filing what they call a 1696 appointment of representative form, then a new attorney comes along, Social Security will not honor a fee petition if there's two 1696s in there unless attorney number one withdraws and waives fees. So I had a case, for example, and Jim, who's been on here a few times, not on today, I don't think, but we won his case. He'd had 2 or 3 previous lawyers. Great case. I mean, it was a really strong case. I don't know what the problem was, but he had 2 previous lawyers. I think one retired, one got out of the practice. I don't know what it was. So I had, withdrawal letters from both. And so we won the case. My fee agreement was approved and everybody's happy. So. Dawn says she's training to hear. So, we're getting a lot of people. Sharon, you figured out how to get not YouTube user. There you go. I knew you could do it. We did this. You always were on YouTube user. Now we got your name and you got a nice picture there. I think if I'm not correct, if I'm not missing the wrong person, not saying the wrong person. Okay, so as far as if you're training to hear, a lot of people are not training, so maybe the volume, I don't know. We're getting close to the end, so it won't be, you won't have to put up with me for too much longer. GC says, it's sad disabled workers have to go through this, even persons with chronic conditions get denied on a regular. Yeah, it's sad. It's sad. You're welcome. I heard, yes, that's correct. That is correct. CDRs have stopped. Thank you, Aaron. I appreciate the kind words. Wow, you fell over unconscious. Well, that shows you how useful these CEs can be, right? Physical medicine CEs. Ooh, you got a 22% approval rating. Yeah, that's not good. That's probably not a good sign. Good sign. Partially favorable. 55 now going 56, possibly. A couple things have changed. One is they're looking at the past work look back is now 5 years, not 15 years. And at 55, a different set of grid rules apply. So very, very possibly. And Joel, you can definitely use the grid rules. Look at the light grid rules. Will CDR come back in 25? Probably, but who knows? Who knows? Transferable skills. I mean, it can be, working on using a spreadsheet. It can be customer service skills. It can be doing inventory. It can be any number of things that can be transferable. But if you have, let's say, severe headaches, or if you have severe depression that makes it hard for you to focus and concentrate, those skills would not easily transfer. At age 60, not only do you have to have skills that transfer, but there's a standard called the minimal vocational adjustment standard, which means that in order for Social Security to prove you have transferable skills, they've got to show that the skills you have would be essentially what you did at your past work. So if you worked in an auto parts warehouse, for example, the skills for doing inventory that might transfer at 55 to a flowers warehouse or flower warehouse or to a bakery warehouse, but at 60, if it's not auto parts, it's not going to transfer. That's the best way to explain it. It's just at 60, the burden on Social Security becomes much more difficult. You're welcome, Sharon. Okay. Okay, so let's kind of wrap this up. Jammer is going to be 55 in a few months, occipital headaches, migraines, post-concussion, microvascular ischemia of the brain, bilateral carpal tunnel. So, okay, a couple more. So, okay. So I think that the carpal tunnel is a physical issue. The other things, the rotator cuff is physical. The other things are probably more, in terms of focus, concentration, memory, stamina, things like that. They're non-exertional. So the grids might apply bilateral carpal tunnel in terms of what you can lift, and the rotator cuff, what you can lift. So you might be able to argue grids, but in the alternative, I would argue functional capacity. When you look at, the non-exertional impairments, the headaches, the migraines, the post-concussion syndrome, the microvascular ischemia, which is a diagnosis really, just proves that something's going on there. But that the memory, mood changes, things like that, that would, I think, be another argument, a functional capacity argument that you could use. Okay, Joel, thank you very much. All right, so I think we're going to wrap this up now. It has been 2 hours, and you could tell from my yawning earlier that it's been a long day for me, but oh, wow, Joel. Okay, I'm sorry to hear that. So, yeah, I think you've got a pretty strong case. I'm very sorry to hear what you're going through. All right, so remember, everybody, next week I'm going to do this on a Tuesday night. So I'll get, when I put the notice out, but just be aware that if you do check in every week, check in on Tuesday nights. And, again, if you have a chance to review me, please do that. If you have a chance to, if you want a case evaluation, here is a link to do that. And, happy to help any way I can. I hope you find this useful. It's always a lot of fun to do it. I'm working on getting some guests, but it's been a little hard to find people, just people have had stuff to do. So we'll work on that. And like I said, I've got an eye on a judge. I'm going to try to get him in here. That would be really kind of cool. So anyway, thanks everybody for your time. I hope you have a great weekend and the rest of your week. No, I don't think it's a transferable skill. But we're not going to mention it at your hearing, Sharon. Let's just put it that way. Okay, so I'm going to leave everybody now. So I hope, again, everybody stays dry, and I hope that the hurricane does not affect you. Sharon, I hope it didn't affect you in Florida. So we will talk again next Tuesday. Thanks a lot.